I was once in court and I watched a case where normally on a California limited authority, you can't sell the property for less than 90% of the appraisal, the inventory and appraisal
Right.
report. And I saw a judge, agree based on certain extenuating circumstances, approve it. And I said, wow, the code says you can't do that, but the judge just did it. And I had a case later with another attorney about a year later, and this situation came up. We had to sell it quickly and below the price. We couldn't get the appraisal done. I said, well, I know that the judge can't do it. Now the code says they can't, but the judge can do whatever the judge wants to do,
Right.
as long as it makes sense and as long as it's in the best interest of the state. How do you kind of play those lines? How do you decide when to push the envelope? Obviously, some things you've seen and you learn from
Sure.
experience. Other, you kind of have a sense of it. How do you kind of play that line a little bit?
Yeah, well, you're right. At the end of the day, the judge can sort of do whatever they want, right? Now, could somebody appeal that decision? Could there be some other mechanism where it could ultimately be a problem? Maybe, right? But for the most part, judges are empowered to make decisions like this every day. Probate court is a court of equity, right? And that is a distinction from, a contract dispute, right? If you've ever been involved in something like that, that's a court of law. That they're looking at the contract. They're determining, did you say you were going to show up on January 5th and put a new driveway in? Yes. Did you show up on January 6th? Yes. Okay, you breached the contract, right? End of story. In that simple example. When it comes to a probate court's a court of equity, and they're really looking at what is fair in these circumstances, what's right, best on this circumstance. So very different. And, that's usually what you're appealing to in a lot of these situations, is that what is right in light of all of the circumstances, what's going to get the most money in the pocket of the beneficiaries, so on and so forth. So yeah, I've seen judges make all sorts of decisions like that.
Now, you mentioned, I think, that you're licensed in several other states. Do you mind sharing which states those are?
Sure. Ohio primarily is my other state that I do a lot of work in. Also in Michigan, but do a lot less. I've actually let my license go inactive there. Did a lot of work when I worked in Ohio. And Ohio, I guess the biggest thing to take away from that is every state is very different on probate, right? Or any areas of law. But in particular, probate is very driven by the state law and then by the county that you're in. Even in LA, right, where we have a lot of different counties around us, LA County, Kern County, all of that. Even though they're playing from the same rule book, the judges are doing things very, very different in the counties. So you really need also, and in addition to having somebody who is, a probate expert, you want to have someone who's an expert in that county that you're in, because it's really important.
I think you're right. And I think knowing those local rules and procedures, and if you can even know the judges, is such a big advantage. I know in LA, it seems to me that almost every judge, almost every time, will delay a foreclosure if it's to the benefit of the estate, almost
Right.
seemingly without any reason. And in Orange County, I've seen judges say, hey, you had your 90-day notice, you had your notice of trustee sale. No, that's the law. They had fair notice, and the lenders, and like, you would never hear that in Los Angeles, but that's more common, not the rule, but more common in Orange County. Can you think of any other differences between counties that stand out that point to the importance of knowing the local county or local rules?
Yeah, a lot of it's administrative. Like, for example, in some counties, you have to file an original death certificate with the petition for probate. Some counties you don't. Different levels of publication in different counties. All these counties have different local forms that you have to fill out. But you picked up on probably the biggest difference, which is how the counties are in utilizing their discretion, right? Because that issue that you brought up, which was probably an ex parte request to, temporarily restrain the lender from, completing a foreclosure, is at the judge's discretion, right? They look at that and they say, okay, am I going to restrict this company's rights or this person's rights over the estate, and basically benefit the estate in light of what the contract says? You're absolutely right. In LA County, they will do that pretty much every time, at least once, maybe even twice, on the same piece of property. In Orange County and some of the other counties around LA, no. You better show that the estate did some really dramatic things to try to keep this from going into a foreclosure, and but for something outside the estate's control, they would have paid.
Yeah.
LA County, not so much. So those are examples where you really want to know where you're at, and talk to somebody who's experienced to figure out, okay, is this even going to work here in LA County?